Well, hello, everyone, and thank you for joining me. I'm Jill Bloom, Group Publisher of Roofing Contractor, and welcome to our Best of Success podcast show. It's always an honor to have with me Trent Cotney, partner with Adams and Reese. Trent, thanks so much for joining me.
Hey, Jill, it's great to be here.
Well, we've got a couple things that are very important for us to cover today, Trent. I know that clearly from what we just talked about, these are making your phone ring. The first I'd like you to cover with everybody, please, could you let everybody know what's happening with multi-employer site doctrine?
Sure. So, for those of our listeners that don't know what that is, let me explain it. So, from OSHA's perspective, when they come out to their job site, they are trying to determine who is responsible for safety. And oftentimes they look for a controlling contractor. So, typically, the way that it works now is that you can have a subcontractor out there on the job. And even if you're not on the job at all and you're the prime contractor, you could still be held liable for their safety violations if OSHA believes that you are responsible for their safety. So there's a variety of things that we do to kind of mitigate against that. We have a very strong, master subcontract agreement that has all the bells and whistles and pushes safety down on the sub. Operationally, we make sure that the subcontractors aren't wearing the prime's gear. They're, logoed high vis. Their logo on the trucks, that kind of stuff. But really, what it comes down to is making sure that your subcontractors or sub labor are responsible for their own safety. Now, that being said, we still want a safe work site, right? Safety is always paramount. So, how do you approach safety on a job site like that? You do it top down. So, if you roll up on a job and you've got a sub crew there, you look to make sure that you're notifying that crew leader and saying, "Look, you're in violation of the contract. This is a breach contract. We're gonna back charge you $100 admin time as a result, but you need to correct this immediately." Now, all that being said, Jill, if let's say you're a prime contractor and you roll up on a job and you see a sub there, right? And one of the employees of the sub is on the, perimeter of a roof about to fall over, forget what I'm saying, go save them, go tell them how to be safe, all that kind of stuff, be a human first and then worry about legal. But the reality is that the way OSHA has it set up now is that it's sort of a catch-22 if you want to be in that prime position and make sure your subs are safe. Now, what are we doing about it? Well, Jill, you and I have discussed plenty of times how this is a receptive administration, how the courts are receptive to challenge. This is something that I've challenged personally before. We brought it up to the 11th Circuit probably about 10 years ago. I think we have a very receptive bench right now, and this is something that I am looking to personally challenge myself. I've put out to our lawyers here at the firm. I said, look, if you run across this and we're in a jurisdiction that you think it would be beneficial to challenge this, let's think about doing that, because I think now is the time. I don't agree with the way that this is interpreted. I think, clearly if I'm on site and I'm causing and I'm an exposing contractor and I'm causing the problem, then yeah, I should be cited. But I think that there should be a carve out. If I'm not actively involved in a subcontractor safety, if I'm not on the job site at all, then there's no way I should be cited for their bad acts. That's what I think personally. But it's a big issue. It's a problem, I think. So.
Yeah, it sounds like a big problem, and at least where you've got the tools to help everybody here and fight this. So thank you for that. But
yeah, we'll see.
I'm sure there's more to come for sure.
Right. Absolutely.
Well, the other topic that I wanted to cover with you, Trent, is down in Florida. It sounds like there's some non-compete changes.
Yeah, absolutely. This legislative session in Florida has been crazy out of control. There are everything from contract changes to lien law changes to stuff that directly impacts roofing to you name it. And a lot of it is pending signature by Governor DeSantis, including what we're about to talk about. But it looks like this may go through. And it's what's known as the Florida Choice Act. And what they're looking to do is make it legal to extend a non-compete from 2 years to up to 4 years. And, there are certain requirements. You got to make at least double the median income. You got to be a high paying professional, right? You can't do it on a low level crew member or something like that. And, the same nuances that would normally apply is the same type of work, that kind of stuff, but this is a very business friendly, piece of legislation here. So it's interesting to see, after the FTC's ban on non-competes was lifted, you've seen some states look to enact their own bans via state law, and then you've seen other states like Florida go, pro-business and say yeah, give them the right to review it, give them a period of time to get with their attorney. If they sign it, they sign it. So going to be very interesting to see how that ultimately plays out. If Governor DeSantis does sign it, it will go into effect July 15th of this year.
Okay, that's right around the corner.
Yeah.
All right. Well, Trent, as always, thank you so much for your insight. If anybody has any questions, where do they find you?
Sure. Email trent.cotney@arlaw.com or anywhere social @Trent Cotney.
Sounds great, Trent. Thanks again. And if anybody has any questions for us, it's roofingcontractor.com or wconline.com. And while you're there, make sure you sign up for all our free content and stay safe and healthy. And we'll talk to you soon. Thanks again, Trent.
Thank you.